Talking with John Barnes with the Attorney General's office. And John, for folks who are concerned about the EPA, a little bit of good news here. So tell us what happened.
Well, Peter, it's kind of a long story that led up to this, but essentially today the Sixth Circuit Court of Appeals ordered the new Waters of the U.S. regulation from the Environmental Protection Agency halted nationwide. Now, prior to this, the Eighth Circuit Court of Appeals had halted that in the 13 states that filed suit in that circuit, and that included Montana. Montana was one of 13 states that had filed one of the initial lawsuits against the Waters of the U.S. rule, and that judge there in the Eighth Circuit agreed with us and placed an injunction against the rule, but that only applied to the 13 states. What the Sixth Circuit has done has applied that to the whole country. So what it means is this regulation from the EPA and the Corps of Engineers that was adopted not too long ago is now on hold. Now, the Waters of the U.S. rule was promulgated by the rulemaking authority of the Environmental Protection Agency and the Corps of Engineers, and what it does is it redefines what waters of the U.S. is under the Clean Water Act. But it is such a broad definition that has been adopted. It's the very definition that Congress has rejected in the past. It's the kind of overreach that even the U.S. Supreme Court has chided the EPA for in the past. And so the states argued that the EPA did not have the authority to do this under the Clean Water Act. If this kind of regulation is to come, it needs to come from the people's representatives in Congress. But as I said, they rejected this. The U.S. Supreme Court has rejected this kind of move. So basically, it's such a broad definition of waters of the U.S. that it creates a tremendous amount of uncertainty for those who use the land in terms of the different kinds of regulatory apparatus they might be subject to. So this could impact farmers, of course, the agricultural industry, ranchers, mining, mineral development, even home developers, builders, local governments, when they look to maintain or expand infrastructure. They might run afoul of some of this because now under the Clean Water Act, under this rule, even things that have very little, if no connection to navigable waters fall under the jurisdiction of the EPA and the Corps of Engineers. And the courts are signaling that they're agreeing with what we're saying, that this needs to be put on hold while the case is tried, and they're signaling that our arguments have legal merit to them. And so this is definitely good news. It was already on hold in Montana, but it's good news for the rest of the country, and Montana was one of the states that helped lead the fight against this initially.
Any idea how long this court battle might take, or when it's going to be initiated?
Well, the litigation is in process now, and there are, I believe, 31 states that have filed suit against Waters of the U.S., and they've done that in different jurisdictions or court jurisdictions throughout the country, so you might see efforts to consolidate the cases. Some environmental groups have also filed suit against Waters of the U.S., but from the opposite perspective, because I don't think it goes far enough. So this could be a very protracted legal fight, and that was one of our points, was this could go on for quite some time, and so it's very important that this rule be halted while all of that is sorted out. And so the courts have done that now nationwide, and so again, this is good news for Montana and for the whole country.